Thursday, March 11th, 12th. And I call this meeting of the Tarpon Springs Code Enforcement Board to order. Thanks for everyone coming today. Mr. Trask, the invocation?
For those of you can stand, I'm going to do an invocation, then we'll do the pledge. Our Father in heaven, we seek blessings on the tasks before us. Bless our efforts with clear insight, our deliberations with wisdom, our work with clarity and accuracy, and our decisions with impartiality. We gather to make decisions for our community. May we use only our best skills and judgment, keeping ourselves impartial and neutral as we consider the merits and pitfalls of each matter that is placed before us, and always act in accordance with what is best for the city of Tarpon Springs and our fellow citizens. This we pray. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
May I have a roll call, please?
Mr. Bessie?
Here.
Mr. Cebulski?
Here.
Mr. Sansoda is not here. Ms. Vicasey? Here. Mr. Kramer?
Here.
Mrs. Archie is not here. Excuse me. Mr. Demasas?
Here.
Mr. Plunkett's not here. Mrs. Dabbs? Here. Thank you. That completes your roll call.
Thank you. We're now going to swear in all witnesses for today's cases. Would everyone?
You need to read this too.
Oh, one moment, please. Code Enforcement Board hearing procedure. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the city of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the circuit court. Such an appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have a record of the proceedings to support such an appeal. The procedure of this board follows, with each case on its agenda, is as follows. First, the city presents its witnesses and exhibits, after of which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make any presentation and present any evidence or documents. Then the city can question the violator's witnesses. After both rounds of testimony, both on the part of the city and on part of the violator, each party is asked to give a closing statement. First by the city, then by the violator. After those three steps have taken, this board then closes the public portion of the hearing and discusses the case amongst itself to take appropriate action. Before we begin the public hearings, we'll have all potential witnesses stand up and be sworn in by the secretary of the board. And please turn off all cell phones at this time.
Do you swear the testimony you're about to give is the whole truth and nothing but the truth?
I do.
Thank you. You can be seated.
New business. Case number 15-800000063. Is there anyone representing this case in the audience today?
Sheila West.
Sheila West, 438 Riverside Drive.
Yeah, if you come down here and step right up here to the microphone. Right over there.
The desk right here, ma'am. And if you haven't signed in, please sign in.
We have some photographs to introduce into evidence.
Well, as they get to them, she wants to show them over here. Sign
Mrs. West, could you state your name and address into the microphone for us, please?
Sheila West. You want the property address or my home address?
Current residence?
1304 Vermont Avenue, Tarpon Springs, Florida, 34689.
Thank you. City, go ahead.
Officer John Org, Tarpon Springs Police Department. This is case number 15-800000063. The address is 438 Riverside Drive. Property owner Sheila West. The tenant is David Lewis. Repeat violator. Previous case number is 14-800000592. Established October 9th, 2014. On 2/9/15, complaint received. Parking boat and trailer on right-of-way on Chesapeake Drive. 2/9/15, inspection conducted, confirmed. There is one boat with trailer parked on the west side of the property outside of the fence. No answer at door, photos taken. Repeat violator of City Code 42.00, parking of recreational vehicle in residential area. 2/10/15, notice of hearing, report repeat violator. Mailed first class and certified return receipt to property owner of record, as determined by Pinellas County Tax Collector or by the Pinellas County Property Appraiser. 2/18/15, reinspection conducted, boat removed in compliance as of 2/18/15. 2/25/15, property posted. 3/11/15, reinspection conducted, still in compliance, photo taken. In violation of City Code 42.00, repeat violator from February 9th, 2015 to February 18th, 2015.
Secretary, will we take those photographs into evidence, please?
Yes, sir.
Thank you. Any questions for the city?
No.
Miss West,
Yes.
would you like to present your side, ma'am?
I'm the property owner, and I have a tenant there. This is my
She's going to have
tenant.
to speak into the microphone. We
I'm
can't hear her
sorry.
at all.
And I depend upon my son and his wife to manage the property for me. I understand that the city needs to keep everything nice, and I agree with all of that. But I've been, trying really hard to keep him in compliance, and I don't know what else I can do. I mean, I don't think I have a right to move his stuff or anything like that, so I don't know what else I can do to make him compliant, so I don't really have any first-hand knowledge of what happened here, so I can't say anything about that. Just ask you to not fine me for it, because I wasn't here, I didn't do it. And I'll do my best to keep it from happening again.
Do you have any questions of officer of the city?
I didn't quite understand what he went out there, you went out there one day because of,
An inspector went out there in reference to a complaint of the boat being parked on the right-of-way.
right, and then they didn't go back for 9 days,
Excuse me?
and then they went back 9 days later to check it?
Is that how many days? He came, your tenant came into the office on, what day was it? February 18th, in reference to the complaint.
Oh, okay. I just, that's it, that's all, thank you.
You're welcome.
Did the board have any questions of Ms. West?
Yes, I have one question. The renter, has he been made aware of the fact that he's not supposed to park the boat there on the right-of-way on the other side of the
Yes, sir.
fence?
Yes, sir, he's been made aware that he's not supposed to do that, and he's been told not to do it
More than once?
more than once.
Any other questions? Okay, at this time, I'm going to close the public testimony, and we can discuss it amongst ourselves and/or hear a motion.
I'll make a motion.
Go ahead.
I move based on the testimony, evidence, facts presented in law, that the respondent was in violation of section 42.00 of the Tarpon Springs Code of Ordinances from February 9th, the initial inspection date, until compliance on February the 18th. A fine of $20 per day for 9 days is imposed for a total fine of $180.
Second.
Roll call.
Discussion.
Any discussion? May we have a roll call, please?
Ms. Dabbs?
No.
No? Okay. Mr. Demasis?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Mr. Zableski?
Yes.
Mr. Vesey?
Yes.
Your motion carries.
Thank you.
Okay.
You're all done, Ms. West.
Okay.
I would just encourage you to get the seriousness of the situation to the tenant as a repeat violation.
Yes, sir. I thought I saw our name on the list twice. Do I need to wait? At the end?
Thank you.
It's an affidavit of compliance. My suggestion is you wait. It's an affidavit of compliance that the board is going to consider that the property is now in compliance. So,
Oh, okay.
You can wait in the audience.
All right, thank you.
Case number 14-800000829. Is there anyone in the audience for 66 West Lime Street, Scott Joseph Fitchett? Will you go ahead and step forward and state your name and address into the microphone, please?
He wasn't sworn.
I need to re-swear. I didn't realize I was a witness, so I didn't swear in.
We'll do it before you sit down then. I'll do it now. Raise your right hand. Do you swear to tell the whole truth, nothing but the truth?
Yes.
Thank you.
Go ahead.
Thank you, sir. This is case number 14-800000829. The address is 66 West Lime Street, property owner, Mr. Scott Pitcher. On 11/24/15, the complaint received regarding a problem with the visibility triangle at this location. I conducted a site inspection and confirmed visibility triangle. 11/24/15, inspection completed. Inspector Cindy Sander conducted a site inspection and confirmed that the bushes behind the picket fence are blocking the view of oncoming traffic from the east when stopped at the stop sign going south on Banana Street, in violation of City Code 37.00 visibility triangle. 11/25/14, notice of violation, mailed to property owner of record as determined by the Pinellas County tax collector or the Pinellas County property appraiser. 12/9/14, office visit. Case discussed allowing property owner to, an extension to bring property into compliance. Inspector Cindy Sander and I, myself, were present. 11/23/15, re-inspection. Officer Gaston conducted a re-inspection southbound on Banana Street at stop sign facing east. There were numerous palm trees with large leaves blocking the view of westbound traffic on Lime Street. 11/26/15, final notice of violation. Mailed first class and certified return receipt to property owner of record as determined by Pinellas County tax collector or by the Pinellas County property appraiser. 2/16/15 reinspection. Officer Gasson conducted a reinspection. Contact, no one was at home. One bush tree on southwest corner is inside the visibility triangle. Notice of hearing on 2/18/15, notice of hearing. Mailed first class and certified return receipt to the property owner of record as determined by the Pinellas County tax collector or the Pinellas County property appraiser. Property 3/25/15 property posted, 3/11/15 re-inspected. I conducted a re-inspection, no change. The one bush on the southwest corner remains inside the visibility triangle. Photo taken. In violation of City Code 37.00 visibility triangle.
Thank you.
Thank you.
Mr. Fitchett, at this time, you could ask Officer any questions and then present your side or anything you'd like to say.
I don't have any questions for the officer.
Mr. Fitchett, I'm sorry, did you state your name and address in the microphone yet?
I didn't. My name is, sorry, I had to redo the swearing in. Scott Fitchett, and I'm at 66 West Lime Street. I don't have any questions for the officer. I've spoken with him before, and just, I had a complaint last year to trim some bushes back, which I did, and then when they did reinspection, I'm really just disagreeing with the definition of what the visibility triangle is. So I've cut my bushes back to a certain distance, and it can be, I guess it's been interpreted one way by code enforcement and by me another way. So that's, I guess, what brings me here.
Officer, do you have any questions of Mr. Fitchett?
No, sir.
Thank you. Okay, at this point, does anyone have any questions for,
Yeah, I'm not sure I understand what you're saying. You disagree with the law, so you're not going to,
Oh, no, I don't disagree with it. There should be a visibility triangle, but the distances that it says, if you have a triangle, a square triangle on an intersection, there's two edges that are square on the corner, and then there's a hypotenuse that connects those two that runs through my yard. I'm reading this saying that, in my opinion, the hypotenuse should be 30 feet. It could also be read another way, which means that the right angles of the triangle would be 21 feet, and my bush is behind that triangle.
okay, I guess from the pictures, it looks to me like if you're sitting at that stop sign and you look to the left, there's a bush in the way, and you'd have to pull out more into the street. So, you know, I don't know about the angles and everything. I just know that if you can't see because there's a bush, then that's why the bush needs to be trimmed back. I mean, did you see in that pictures that that's what it looked like? That if you're at the stop sign, you can't see. I learned to appreciate the cities having these laws, because in other cities they don't, and I find myself having to pull way out in an intersection because there's no code enforcement keeping those signs, you know, the area clear so you can see. And so that's, I guess if you can't see, the bush needs to be cut back.
I have a
Any other
question for
questions?
the officer, if I might.
Yes.
Officer, you made this inspection?
I went out in the initial complaint and determined there was a violation. Officer Gasson, who was on, right now he's had an injury, he's not on duty. He went out there and did the actual measurements that you see in the picture.
Okay. Well, without discussing the measurements, let me ask, in your opinion, does it obstruct the site for the stop sign? Or
Absolutely.
it might cause an accident?
Yes, sir,
And there's
absolutely.
no doubt in your mind?
There's no doubt whatsoever.
All right.
okay, any other questions? All right, I'm going to close the public hearing at this time. And would there be any board discussion? Would anyone like to make a motion?
Hit it, Sherry.
I'll make a motion. I move based on the testimony, evidence, facts presented in law that at the time of the alleged violation, Section 37.00 of the Code of Ordinances of the City of Tarpon Springs was enforced. The respondent has until the first day of April to come into compliance with the code sections, or a fine of $25 per day shall be imposed for each day thereafter the respondent remains in violation of the code section.
Second.
Any discussion? May we have a roll call, please?
Ms. Dabbs?
Yes.
Mr. DeMasis?
Yes.
Yeah.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Mr. Zagleski?
Yes.
Mr. Vesey?
Yes.
Motion carries.
April 1st, please. Thank you for coming.
Sure, you didn't ask me if I had any final comments. Is this a good time to make that, or is that it?
Yes, this would be a fine time to make that. Thank you.
If there's a discrepancy in how the rule is translated, how would I go about having that clarified? That's the whole reason
I
that
think
was
that's a
here.
very fair question. Mr. Trent?
The board has already made a decision or a ruling. They've closed the public hearing. They've received all the evidence and made a determination that there is a violation. If you believe that the board has not complied with the law, you have the right to file an appeal with the circuit court. You have to do that within 30 days, and the court will make a determination whether or not the code enforcement board acted appropriately based upon the testimony and evidence that it received. They've made a determination that there is a violation. You understand?
I understand. The reason I thought I was showing up today was to go over the misinterpretation of the rule. So I guess if it's already closed because you had done a roll call or something like that, then I guess that's it.
They received the testimony and evidence and closed the public hearing. That's correct. You had the opportunity to provide your testimony, and you did do that.
I disagree with that, but
But you're right.
Okay. So the board has ruled at this point, so those are your options. The options are to file an appeal or to come into compliance by April the 1st or suffer a fine of $25 a day.
okay, I think a better job could have been done at figuring out how I would have presented the whole reason I was here to begin with.
If I may.
You're the chair.
And I think I understand your point is that you felt perhaps we moved a little quickly. I don't want to speak for the board, but I think I understood your presentation. You gave it pretty clear, is that how you interpret how the rule is laid out, you would measure it differently. You were pretty clear in right angles and lengths.
I measured it exactly the same lengths as the officer did. My issue was there was a measurement given of 30 feet that I believe was translated incorrectly.
Okay. I understood, and I don't want to speak for the board, but I think everybody understood his presentation and understood and such, so.
I guess it doesn't matter what the things are. If it's a potential accident, then it's like a no-brainer.
I guess I'd just
think
like
I
to
heard all I
take the
needed to
time and
get.
say, we did hear and we did listen.
Thank you.
You're welcome. Thank you for taking the time to come.
Sure.
Our next case is 15-2000001. This is a repeat violator for Athenian Way. Is Mr. William Ziering in the,
I'm his attorney, Herb Elliott. This is the property manager.
thank you. Were you both sworn in?
Yes.
And would both of you speak your name and address into the microphone, please?
Herb Elliott, 1111 Riverside Drive, Tarpon Springs.
Natalia Fletcher, 31177 US Highway 19 North, Palm Harbor.
Thank you. Hi.
Thank you.
And for the city today,
Officer Lemon with Tarpon Springs Police Department.
nice to meet you. Go ahead, officer.
It's in reference to case 2015-200000001, Athenian Way, vacant lot, parcel 12, 2715, 00965, 000003. They are a repeat violator based on previous case number 2012-200000026, which was taken on 11/8 of 2012. On 1/30/2015, at approximately 19:30 hours, I responded to the Anclote River Crossing Development, Athenian Way, in reference to a trespassing complaint. Specifically, I was informed that a valet company employed by Ballyhoo Grill was utilizing Athenian Way as a point of entry to park vehicles on a parcel of land located at 0 East Live Oak Street. The point of entry from Athenian Way required the valet company to traverse a section of land on the south side of Athenian Way, which is owned by the Anclote River Crossing Association Incorporated. I took photographs of the entry point on Athenian Way that had signage indicating it was a restricted area being utilized for valet storage. I noticed visible tire tracks leading from Athenian Way onto the property being utilized by Ballyhoos for additional parking, and these tracks were also photographed. I observed approximately 15 vehicles parked on that lot. The photographs taken have been placed into evidence. Sergeant Brockey and I made contact with the manager of Ballyhoo Grill, Anatalia Fletcher, who advised she didn't realize that gaining entry onto the property from Athenian Way wasn't permissible. Anatalia indicated she would inquire with the owner of the land, William Ziering, to determine the feasibility of creating an entry point onto their property from Live Oak Street. Anatalia advised she would immediately cease having vehicles parked on that property, so no further enforcement action was taken at that time. The actual ordinance sections are 1.4, Smart Code Process, Site Plans and Conditional Uses, 1.4.1, Smart Code - Site Plan, and 1.4.2, Smart Code Conditional Uses. The code ordinances, Appendix A, Section -209.00, Conditional Uses, and Code Ordinance, Appendix A, Section 210.00, Site Plans. On 1/31/2015, they were in compliance. February 10, 2015, there was a notice of hearing provided to them indicating that they were a repeat violator. On February 25, 2015, the property was posted, and on reinspection on 3/11/2015, they are still in compliance. The property is classified as a repeat violator from January 30th, 2015 to January 31st, 2015.
No questions.
Thank you. You'd have an opportunity at this time to make any presentation you'd like.
Thank you. Okay. State your name, please.
Anatalia Fletcher.
And what is your current occupation?
I'm a manager of Ballyhoo Grill.
Okay. Getting back to the events of January 30th of this year, can you please tell the board what happened?
Basically, as Officer Lemon said, I asked the valet people, we ran out of room in our parking lot. We had a special event that night, and I knew that we owned the property across from us. I did not know that the parking from the grass was not, I honestly didn't know that when you go over that, that wasn't our property. So I thought that we could park there because I knew that the owner had purchased it. He never had spoke to me about this happening before, and I guess 2013 is when it happened. And I had no idea that we were not allowed to park there, or I would have never told them that it was okay. I apologize. I never thought something like this would happen from just telling the valet. So we had no room across the street or over on the other side just to park there, so I apologize again.
Thank you.
Thank you.
Officer Lemon, any questions from our violator?
No questions.
Thank you. Does anyone on the board have any questions of the violator, Officer Lemon? Would anyone like to make any final presentations?
City first.
City first, please.
Yes. From the very first interaction that I had with her to advise her that she was in violation of the city ordinance, she was unbelievably cooperative. They immediately acted in good faith on the violation, ceased parking, valet parking on their property. We've had no issues since then. They've been completely in compliance. So it's my opinion that a fine wouldn't be needed in order to be able to obtain compliance since they've responded to our concerns in relation to the property immediately upon being advised of them.
Thank you.
I appreciate the professionalism of the Tarpon Springs Police Department. Thank you. And it won't happen again. We're sorry, but thank you.
Okay, at this time, I'll close the public testimony, and we can entertain any discussion.
I just have one concern, and I hope you're the manager there for a very long time, but if she is replaced, will the owner make sure and tell future managers that this is a situation, or?
No, we're actually going to, he wants to put up signs, no trespassing. We're putting up, like, I've got somebody building, like, in so many feet, they're gonna have no trespassing with poles in there.
Okay, just, you
Yeah,
know,
no, I don't want this ever to happen again, so,
and I appreciate that you were cooperative with the police
Yes.
department.
thank you.
Okay. So just, we did close the public portion of it, so we'll just have to discuss
Oh, I'm
amongst
sorry.
ourselves. That's okay. But I think we learned something.
I agree with the officer that I don't believe that Ms. Fletcher or her attorney knew about the case back in 2012. I don't think she was here at the time. We had a heck of a problem with that parking issue. So I agree with the officer. I don't think any, I don't know how to do this, if you want to do
I believe we have as kind of a standing, just as an in violation,
And there is
open,
no fine.
that's what.
with
that's
no
all I
fine.
would-
So I'd be happy to
I
take a
would say.
motion at this time.
I move based on the testimony, evidence, facts presented in law, that the respondent was in violation of section, oh, God,
Second,
okay. 1.4,
okay.
1.4.1, 1.4.2, 209, and 210 of the Tarpon Springs City Code of Ordinances from January 30th through January 31st. There will be no fine.
Second the motion.
Any board discussion? A roll call, please.
Ms. Dabbs? Yes. Mr. Moses?
Yes.
Mr. Kramer?
Yes.
Ms. Vacasie?
Yes.
Mr. Sobolewski?
Yes.
Mr. Bessie?
Yes.
Motion carries.
Thank you very much.
Have a good day. Thank you for taking the time for coming.
Let's go.
Case number 15-8000033, 1674 Seabreeze Drive. Is there an Alan Pendley?
His power of attorney, which will present, Ms. Kaplan-Harris.
And have you both been sworn in?
Yes, sir.
And would you state your name and addresses into the microphone, please?
Larry Crow, attorney for the applicant, 1247 South Pinellas Avenue, Tarpon Springs.
Georgia Kaplanaris, 1742 Lake Cypress Drive in Safety Harbor.
And for the city today, Officer Lemons?
Officer Lemon, Tarpon Springs Police Department.
Go ahead.
There's also going to be neighbors that would like to speak on this matter.
Thank you.
This is in reference to the property located at 1674 Seabreeze Drive, property owner Alan D. Penley. On 12/31/2014, I was advised of renters at 1674 Seabreeze Drive and was asked to conduct an investigation to ensure that they were renting in accordance with zoning restrictions that govern that neighborhood. On 1/2/2015, at approximately 15:30 hours, I made contact with a renter at 1674 Seabreeze Drive who advised he had arranged to stay at that residence for a period of 1 week. According to Benjamin, he had arranged to stay at that residence between 12/27/2014 and 1/03/2015, and he believed he had made his reservation through the website VRBO in April. Benjamin and his family only stay at that residence for a period of 1 week, which is a violation of the 6-week minimum stay requirement governing that neighborhood. On 1/26/2015, notice of violation and notice of hearing was provided to the homeowner. On February 25th, 2015, the property was posted. When I re-inspected the property, I discovered that the property was still not in compliance and was being actively rented to someone in violation of the city ordinance. There is currently someone staying at the property for a period of 1 week, beginning on March 8th to March 15th. The residents I spoke to personally are Lisa Hicks and Jeff Asanmi. They advised that they had rented the property for only 1 week and had been advised by the representative, Alan Penley, that she knew that that was in violation of the law. So this property, I'm asking still be shown not in compliance.
Thank you. Any questions from Officer Lemons? Ford?
Yes, sir. Officer, do you have any knowledge of the previous issue that the property had with the code enforcement in March of 2014?
Specifically, not March of 2014. I began working on this issue probably October of this past year in conjunction with Inspector Sanner. I know Inspector Sanner had been involved with this property and with this issue on Seabreeze for a considerable amount of time, but I can't speak to my interaction or involvement with this property prior to October of last year.
When you spoke to Ms. Sanner, did she mention anything about the interaction with the homeowner in March 2014?
There was a concerted effort by Inspector Sanner to explain that renting the property for less than a period of 6 weeks was in violation of the law and that the homeowner needed to come in compliance. There was an arrangement that was made that there was dispute between the parties whether or not there was a pre-existing an arrangement to honor pre-existing commitments. All I can speak to that is that prior to Thanksgiving of last year, I personally met with the representative of Alan Penley, spoke to her and asked her, because there had been such an issue with the neighborhood as far as this property not being in compliance, to provide me with a definitive date that the property would be brought into compliance, would no longer be rented in violation of the law. I was instructed by the representative of Alan Penley that Thanksgiving of last year would be the last time anyone rented that property for a period of less than 6 weeks. Since that time, she has continued to rent the property in violation and advised me that it was a misunderstanding, even though when I spoke to her, I specifically asked for a definitive date and was provided that as last Thanksgiving, but she continues to subvert the law.
No further questions. Thank you.
This would be your opportunity for any presentation.
Well, hold on a second now. I think that the officer said that there are other witnesses that wanted to testify on behalf of the city, and so we would need to do those before we got to Mr. Crow's case.
Thank you.
Right.
We'd ask any additional witnesses to,
Yeah. If you have not been sworn in, have you been sworn in? Okay. And if you could step right down here and get next to the officer, we'll have you testify from there. If you could state your name and your address, please.
Thanksgiving. Okay.
My name is Carol Johnson. I live at 1679 Seabreeze Drive in Tarpon Springs, zip code 34789. I looked at the website on VRBO. There are 47 reviews posted on the VRBO website for 1674 Seabreeze Drive. They date from May 2012 through January of 2015, which is 242 weeks. 47 rentals of 6 weeks minimum would cover 282 weeks and would assume every renter posted a review. Of the 47 reviews, 17 do mention how long they stayed. 1 for 2 nights, 10 for 1 week, 2 for 10 days, 3 for 2 weeks, and 1 for 4 weeks. None of the 17 stayed for the 6 weeks minimum. Also, 13 of the 47 reviewers mentioned the number of people who stayed at 1674 Seabreeze Drive. 2 reported 7 people, 1 8 people, 1 9 people, 2 10 people, 2 11 people, 3 12 people, and 2 15 people. The advertisement advertises that the home accommodates 14 people. One other comment I'd like to make is on July 3rd of last year, 2014, Cindy Sanner notified me by email, and I could provide that email, that the 4 properties were being cited. There are four rental properties that are violating the law, of which this is one, and told to cancel any existing commitments, and that the owners of the properties were given a compliance date of July 21st, 2014. And I also have copies of the 47 reviews if you'd like to see those.
Okay, if you could hang on there just a second.
Yes.
Mr. Crow, you have questions?
Yes, ma'am. Did you write a letter to the city, an email to the city commission on June 16th, 2014 concerning this matter?
I don't recall writing a letter. My husband spoke at one of the commission meetings in June, and we weren't talking specifically about this property, but others as well. I guess I did submit a letter, and also I think Frank Perry also submitted a letter. But we also spoke at the commission meeting.
And I do have a copy of the letter.
Okay.
What I want, and I'm happy to share it with you. In that letter, did you not in fact state that the code enforcement board did inform you that they did allow the property owner to honor existing contracts?
That was what Cindy said later, but on July 3rd, she wrote and told, and I have the email. If I can get a connection, I can pull that up. But in her email, she said that she changed that statement and said that she had told them that they could no longer honor existing contracts. The other 3 properties in question stopped renting. They are now renting again now, but they had stopped for the summer and fall.
Yeah, I think this letter is dated June.
Correct. July 3rd was later than that. And in June, Cindy had said that she couldn't tell them that they had to cancel existing reservations. In her email to me of July 3rd, she contradicted that. I mean,
Okay.
I'm only stating the facts that were in the
Thank you.
email.
I appreciate it. Thank you. No other questions. Thank you.
Do the board members have any questions of the city or the witness? Or any questions of our violator?
I would have a question for you, sir. It seems like, even though it was addressed, or maybe there was a little bit of confusion in July of 14, that we can't make people who've already made reservations, deposits change. But that was, what, 9 months ago, 8 months ago? And it's still happening now. Do you have an answer for me, per se? Why are we still insisting to violate the City of Tarpon Springs codes that you have to rent a property for 6 weeks or more? And it seems like it's still happening. I don't know why the word's not getting to the owner that, hey, you're not supposed to do this no more.
Let me just interrupt for a second. Procedurally, I want to get back on path. The question by the chairperson was, did you have any questions of the witness? They haven't even put on their case in chief yet. We need to allow the city to finish their case in chief. I don't know if there are any other witnesses, and then maybe we can come back to that, and Mr. Crow and his client may be able to ask it at that point.
Are there any other witnesses for the city at this time that would like to speak?
Okay. Knowing that, now it's Mr. Crow's case.
Go ahead, Mr. Crow.
Yes, Mr. Vice Chairman, we do have a presentation which I think will logically explain all this, but in direct answer to your question, I have personal knowledge about this because when this originally occurred in March 2014, which is what I keep alluding back to, I had met with Ms. Sanner and explained to her that a lot of these reservations were in the works as of that time for the ensuing year, because these type of properties, like a vacation rental book up like that, as a matter of fact, and Ms. Kaplan-Harris will testify, is those contracts go through April of this year. And there's a question about the timing, which she can clarify, but I think if you'll give us an opportunity to present our presentation, we can clarify that issue as to why these weekly rentals are still ensuing based upon that March 2014 agreement by the city.
Now would be a wonderful time for that presentation.
Thank you, Mr. Chairman. I'd like to call Ms. Georgia Kaplan-Harris. I'd like to just question her directly. If I don't know, I understand the informal procedure, and I would like to submit her duly recorded power of attorney for Mr. Penley for the subject property.
Please.
Thank you. And I do have copies of each one of these for the members of the board, if it'd be your pleasure to.
No, we need to first of all show it to the city and see whether or not they have any objections to any of that coming into evidence, and then we'll only use one copy that we'll send from that end, this end, Mr. Crow, so that we can mark them as exhibits, so they're all looking at the exact same exhibit.
Yes, sir, I have 5.
Thank you. So, the city needs to look at those, see if you have any objections or not. If there are no objections, then start passing them down, and then, Mr. Chairman, you would allow them to be accepted into evidence.
Would we allow him to go on with the presentation? You can go ahead and continue, Mr. Crow.
I'm sorry, sir?
You go ahead and continue with your presentation.
Okay, thank you. Ms. Kaplanaris, you've already stated your address for the court record. You are the registered power of attorney for Mr. Penley,
I am.
and for the record, that's the exhibit, I'll call it number 1, that we presented to the city. Do you recall code enforcement contacting you in approximately March of 2014?
Yes, I received an email from Ms. Sanner.
And what was the issue at that point in time with regard to the code enforcement?
She said that I had to cease renting the property for a period of no less than 6 months, that the law stated in the residential area that I was in, there was a 6-month minimum.
Months?
6 months is what I was told, and that is in my emails from Ms. Sanner. Yes.
And at that time, did you have a discussion with her concerning your existing contracts, which would run through April of 2015?
She was at the home one day posting a sign, and I attempted to speak to her and discuss these contracts. She said that it would be resolved within code enforcement. I received a couple of emails that told me I had to change my website, putting up a 6-month minimum rental, which I immediately did that. I advised her that I did not know that at the time. I put it in several areas of the listing, and I went along and did everything that they asked of me to do.
So at that point in time, in approximately March of 2014, you changed your ads to state a 6-month minimum?
Absolutely, yes. It said 6-month minimum, minimum rental, and where it said weekly rates, I put 6-month minimum in 4 or 5 different spots of the VRBO listing to appease her.
And did you exchange some emails with Ms. Sanner at that time, culminating in an email from her dated March 11th, in which she said you were in compliance and the case was dropped?
Absolutely, and she also called me via phone.
And what'd she tell you?
She told me that she appreciated me doing what code enforcement had asked, that the 6-month minimum period was okay, and she thanked me for cooperating with the city.
And at that point in time, did you have existing reservations for weekly rentals subsequent to March 2014?
Yes, most of the people that have rented this property either rent it anywhere from a year to a year and a half in advance.
And are you aware of a city commission meeting in June 2014 where the minimum rental period was clarified to not be 6 months, but was in fact clarified by the city commission to be 6 weeks?
Yes, I was actually at this meeting.
And are you aware of a letter that came in that I previously alluded to from Ms. Johnson, in which she acknowledged that the code enforcement would allow you to honor your existing rentals?
Yes, I am.
And that, for the record, is Exhibit 3. And at that point in time, did you change your VRBO ad to reflect a change from 6 months to 6 weeks?
I changed it in the header, the main header. I couldn't change it in one portion of the listing, so I went below and put 6-week minimum rental again, and she said that she did not like that and it wasn't in compliance. I had contacted VRBO to have them change it. They said that they were in a process of redoing their whole VRBO system to accommodate every city in the U.S. So it was probably about a couple of weeks later, because I had to take the ad down and then repost it, that I was able to do it exactly as the city wanted it.
And you've submitted that as Exhibit 4?
Yes, I have.
And from the point in time where you changed your ad, do you rent anything less than 6 weeks at the subject property?
No, I've actually only gotten 6 inquiries over the past 6 months that have requested weekly rentals, and I advised them that that's not possible, and unfortunately, the property was not available for that type of rental.
And at the time that the property was posted this year on February 25th, was there a renter in the property?
Yes, there was.
And what period of time was that for?
He rented the property from January 17th until the 28th of February, which was a 6-week minimum, and this was the 3rd time that they have rented it for a period of 6 weeks or more.
And that particular lessee is Neil Carbone?
Cerbone.
Cerbone,
Neil
sorry.
Cerbone, and he had another gentleman there with him, his partner named Thomas.
And for the record, that's attached Exhibit number 5 that we've provided to the city. And currently, when you correspond with anyone, are you very clear that you will not rent the property for less than 6 weeks?
Absolutely. It is all over my listing. That's why I don't get any inquiries anymore.
And with regard to that, in the existing rentals that were in place as of March 2014, when did those end?
April 25th is the last day that someone would be there of this year, April 25th. After that, I have absolutely no rentals.
And I do want to ask you, ma'am, Officer Lemon alludes to a conversation he had with you around Thanksgiving concerning ending any weekly rentals as of Thanksgiving. Will you give your statement with regard to that conversation?
I saw Officer Lemon drive through the neighborhood. He visited the home across. I was outside doing some yard work. He came over and asked if he could speak to me, and I said, yes, I would love to speak to him. We discussed the weekly rentals. He had told me he had just been assigned to this case. I had told him of the discussion that I had with Cindy Sanner, and also your discussion with Cindy Sanner, that I was told that I was going to honor my existing rentals. He did ask me when those rentals were going to go through, and I said, as of right now, I have the November Thanksgiving would be this year's last weekly rental. I said, we come to the home ourselves personally for the entire month of December. We are usually there with our families. We bring family in from out of state. After that, I had Mr. and Mrs. Cerbone that were there for 6 weeks, and I told them that I had a few rentals that would trickle in through that time period.
And so therefore, ma'am, do you believe you're in compliance with what the city had asked you to do concerning the minimum rental time as of this point in time?
I have done everything that the city has asked me to do, everything. From ceasing my rentals to honoring my existing rentals. I have done anything, my websites, everything that they have asked, I have complied with everything.
I have nothing further for this witness. Thank you.
Thank you, Mr. Crow.
Was there any objection on any of those exhibits?
No, sir.
Okay, so you have 5 exhibits now that have been tendered. Mr. Chairman, you either need to accept them into evidence.
At this time, we'll accept these exhibits into evidence. 5. Does the city have any questions?
I just want to clarify. When we spoke, the incident you were advising the board about, where I spoke with you in your front lawn prior to Thanksgiving, you're advising that during that conversation that you not only said there wouldn't be any more rentals that year, but that then you advised that there would be additional rentals in violation of the law following that new year. Is that what you're advising?
I advised that I was doing everything in my power to comply with the city, that I did have existing rentals, that I would have Mr. Sorbonne there with his partner for 6 weeks, and that I had a couple that would trickle in after that, and then I was done. I was going to try and rent the home on an annual basis, because I did not want to fight with the city. It's not worth fighting. And at the time when I started renting the home, we were never told. We were never told that there was a minimum. And when we were first approached and told there was a minimum, it was the incorrect minimum. There was never a definitive answer as to what the minimum time period was.
Did I, during that conversation, do you remember, did I ask you for a definitive date when your residence would be in compliance?
I believe you asked me when my rentals would be ceasing.
So a
And
definitive,
I said at the time that for this year, my last rental was November. There was a week. Now, prior to that, there was, I believe it was the end of August, and the home was vacant for half of September, October, just about all of November, and then December, my family and Mr. Penley and his family, we all spent holiday time there. So if I was purposely defying the law, I think that I could have rented the home September, October, November, whatever, because honestly, the home had been rented, in prior years. But I ceased renting it. I did what the city wanted. I put the minimum, and I have not signed any new rental agreements since I was told that they were going to honor our existing rentals. Because I advised you, I did not want to fight with the city. It wasn't worth the fight. I didn't want to fight. And there are no, I have some trickling rentals, but April 25th would be the last one. You posted, or whoever posted the notice on my front lawn, and they were legal. Those people were there legally. They were 6 weeks.
is there anyone currently renting your property right now?
Yes, there is. One of the officers visited them.
How long are they renting?
They're renting for a week. This was a rental that I booked a year ago, prior to this whole episode starting.
No further questions.
Thank you. Final presentation by the city?
Since I've dealt with this issue, it's been a long, contentious issue that has definitely affected the neighborhood that they live in. One of the reasons that I was brought in is due to the amount of community concern about houses in the area being rented in violation of the law. The moment that I took over this issue, I made a concerted effort to both engage the residents that had concerns and also the representative of this property, and in the hope that I'd be able to alleviate the problem through just mutual engagement. I specifically spoke to her and was advised that the last rental in violation of law would be in Thanksgiving. I took her on her word on that, and she has continued to subvert the law from that point forward. What I would ask the city is unless you take decisive action, and since she's not in compliance, and impose a fine, that her actions are not going to be cost prohibitive. She is not only violating, but her continued violation, she's profiting from a considerable amount. If you look at their one of their exhibits, it lists that the property is being rented for $12,000 a month. So this violation, unless you guys take a stand, she has no incentive to stop because she's profiting a considerable amount from it. So I've already tried, and Cindy Sander prior to me has tried engaging her and trying to find an amicable solution that wouldn't entail coming before this board and asking you guys to take action. But after concerted effort on our part and the community's part, we have been unable to get her to come in compliance with the law. So I'm asking you guys to take a stand against this issue and impose a fine that will make her think twice about being in violation of the law. Thank you.
Thank you. Any closing comments?
Yes, thank you, Mr. Chairman. Board members, there's no question that there's a reason for the ordinance the way it is for 6 weeks minimum. I would submit to you that based upon both Ms. Kaplan-Harris's meetings and my meetings with Ms. Sander, basically a year ago, she was allowed to keep her existing rentals. Now, in all due respect to the officer who was very courteous to my client, which we appreciate, there seems to be a difference of opinion as to when the rentals ended. But I can say definitively that as of the violation notice, that was a 6-week rental. And so, in essence, I would simply ask that she would be allowed to finish out her existing weekly rentals as existed March 2014 as of April 25th, 2015, and then certainly we would not be in objection to a fine after that date because there will be none. Thank you.
At this time, I'm going to close the public portion of the hearing, and the board can discuss it.
Mr. Kramer is asking what the code provides, and I'm just going to go ahead and read the code provision so that everybody hears it at the same time. I just got to find it. If you can just hang on a moment. The first code provision that you've got under Appendix A, Article 14, Section 241.00 definition, subparagraph 213, which is the definition of a tourist home. I'll read that definition to you. Tourist home, a single-family detached dwelling where the primary use is to provide temporary lodging accommodations for compensation to transient residents, especially motor tourists and or travelers. A transient resident shall mean a visitor to the community who does not use the dwelling as a principal residence, who is either gainfully employed in the community, is neither gainfully employed in the community, nor a student currently enrolled in a school located in the community, or who resides in a dwelling for 6 weeks or less. The term tourist home shall not include a hotel, motel, lodging facilities, or boarding homes. Tourist homes shall not be located within 1,200 feet of a pre-existing tourist home. The locational standard shall be measured from the nearest property line to the existing home to the nearest property line in the proposed home. And I'm going to read Section 25.02, Single-Family Residential District. Section 25.02, it's titled Single Family Residential Districts R100, R100A, and R70A. Subparagraph A provides the single-family residential districts are established to provide for detached dwellings in a variety of districts with a full range of dimensional and density standards compatible with the established development of the area. And then it goes ahead and lists the permitted uses, none of which is a tourist home. And then under conditional uses, it lists 11 of them, none of them which are a tourist home. And then it goes into the regulations relating to the size of the lots and the density of the lot. And then it completes with intensity standards. The reason it's cited under this is tourist homes are specifically not allowed in that particular section under that code provision. But it's not considered that if it's rented for 6 weeks or longer. So that was the key question you were asking. It's 6 weeks.
Can I ask when that 6-week ordinance was put into effect? Do you know?
It may, yes, it may be here. Let me just find out. It's been years.
been more than a year.
Yes, it's
Okay,
been,
okay.
it's been several years.
Okay.
Let me just see the last update. It will tell me here what the last update is. The last update to the definitional section of the code was September 6, 2011.
Okay.
That particular provision could have been revised prior to that, but I can tell you that pursuant to this code, it's been at least in existence since September of 2011.
Mr. Chairman, I understand people say that Ms. Spanner told someone that it would be okay to keep the rentals that you already had booked, which apparently ends sometime in April. That's what I think I heard. I haven't seen proof of that either way. I don't know if Ms. Spanner did that verbally or if that was in writing. If it was in writing, we haven't seen that, I don't think. So to me, I don't think we have all the facts. We don't have all the data. I heard people say that she was going to be allowed to continue to rent with what was already on the books, which I think is nice, and maybe she did say that, but I don't think we've seen it. And in fact, if she didn't see that, if we don't have that was written, then there's a huge violation here. But if we do have that, then we have other.
We'll have to work with the
roads to
facts
go
that have
down.
been presented to us today. So the facts that have been presented today is what we're going to base our decision upon. I did want to make a special, thank you, that Officer Lemons was asking for this case to be established.
And that I would have no objection to, and then I think that's appropriate, but we still have a couple of rentals, in my mind, in question until the end of April, that are still going to be booked in there that we don't have proof that was truly allowed to her as an exception to the code, which was just read to us.
So as I understood, Mr. Crow's presentation was that they were requesting a date of, I believe it was April
25th was the
of no violation. Mr. Lemons, perhaps you wanted to comment on something I just said. Go ahead.
I just wanted to clarify. Initially, we were trying to establish this, but the fact that the property is still not in compliance and the fact that the law is still not being abided is that I'm looking for more than just simply having it established. I'm looking for fines in order to be able to change this course of conduct and bring it within compliance.
Thank you for the clarification. So, in fact, as you heard what he said, it's not an establishment that the recommendation from the city is that a fine is applied at a date. Any more discussion of the board? I would like, am I allowed to make any discussion?
I'm gonna go
Yeah,
with
absolutely.
Okay.
You just can't make the motion. If you want to
Okay,
make a motion.
so I'm not
you
interested
pass
in
the
making a
gavel.
motion. I just want to point out two things, is that I don't know if the person doing the leasing is licensed in any way, but it does fall, the burden does fall upon someone that is acting as a professional renter to understand the law that they're renting in, period. And then I would also, in my opinion, say that it's a stretch of the imagination that the rentals that are occurring right now happened or were put in a year in the past. There's just no way to determine. That could go on forever. Oh yeah, that was booked before. I just find that very kind of a stretch of the imagination. That's just my opinion.
Yeah. I guess I'm a little concerned that 6 months was getting thrown around here. That's a little troubling when it's actually 6 weeks. And, we didn't see any evidence that Cindy did say you can go ahead and rent the places out that you've already gotten rented. And, when somebody's got a reputation for having a great place, people do reserve years in advance. I know that. But lastly, we're talking now 1 more month until they will not do it wrong again. And, I don't know, there's just a gray area here. I'm all for establishing, but I'm just not too sure.
Well, we certainly
about
have to
fine.
establish. And then if we
I'm a
just
little
establish,
troubled.
we have to live with the fact that's going to be rented weekly until the end of April.
Last but not least, this
Right,
would be
wrong,
my
or
last
indifferent.
comment is...
We don't really have enough facts to make that determination.
We did have a resident witness that is expressing pretty serious concern about the state of their neighborhood, and perhaps that needs to be taken into account, just not the good testimony of our witness. Okay, I'd like to hear a motion at this time, please.
Nobody wants to touch it.
See,
It's like page 3 or 4, Jerry.
yeah, but what dates?
I don't know.
Take my time.
Take your time.
Because technically it's not in compliance if they still have.
And it started back in a year ago.
I'd sure like to see paperwork saying that Cindy did.
Yes.
They could do that. I don't know how we can find it. I mean, I don't know.
Okay.
I feel like the pressure's on you if you know.
Oh, no.
Would anyone, at this time, is someone prepared to present a motion to the board?
Yes, I'll present a motion.
That page.
Yeah,
It's like-
the next one, yes.
No, it's like 2 or 3 back, depending on which. It's not in compliance, so you gotta go on the one that's not in compliance. No, the back.
It's right here. Call a motion, respondent's violation of not complying. Property
All right, it's the 3rd page.
Yes.
No, I'm sorry, it's
Second.
the 2nd page.
Second. I move, based on testimony, evidence, facts presented in law, that the respondents were in violations of Section City Code 25.02, City Code Appendix A, Article 14, 241 definitions, 213 tourist homes of the City of Tarpon Springs Code of Ordinances from the initial inspection date, going by the paper that I have here in front of me, of 12/31/14, until the property is brought into compliance, a fine of $0 a day will be imposed until compliance is achieved, but to establish that this does not happen again after April 26th.
Second.
Okay, I need to just jump in. The motion needs to provide that it either was or was not in violation, and a dollar amount of a fine subsequent to your date of April 26th. You don't need to determine whether there's a fine, but prior to April 25th, but you definitely need to put in a fine after April 25th. Otherwise,
Okay.
what you've basically done is said, you're free to go, do whatever you want.
Okay.
No teeth.
Anytime before April 25th and anytime after April 25th.
Okay.
So.
All right, then, let me revise that. I move, based on the testimony, evidence, facts presented, and law, that the respondents were in violations of Section City Code 25.02, City Code Appendix A, Article 14, 241 definitions, and 213 tourist homes of the City of Tarpon Springs of ordinances from the initial inspection date. Now I go with April 26th.
No.
No? What? I want to say that after April 26th, there will be a $100 a day fine if they are found in violation again of said ordinances.
Second.
Okay, for just clarity's sake now, so that everybody understands the motion, your motion is that they are in violation, They have until April 25th, 2015 to come into compliance, and should they fail to come into compliance by April 25th, 2015, that there will be a $100 a day fine for every day that it continues to be in non-compliance.
Yes.
Okay.
Second.
I'll second that one.
Is there any board discussion?
I would suggest that the fine be $200 a day, since the property rents, we've had some testimony, or at least reference that the property rents at $12,000 a month. $200 a day is $6,000. And I think that we want to send a message that this is not going to be a profitable way of doing business anymore. And we already have the assurance, though, of the property manager, it's not going to happen, so, but I think that $200 is more significant than $100. I wouldn't want it to become a situation where somebody might say, well, it's only costing me $100, but I'm still getting, I want to make it so that it would hurt if they violate, which they've assured us they're not going to do it anyway. So I would suggest $200 instead of $100.
Ms. Dabbs, do you have any comments?
No, I just asked, I thought she seconded the first motion.
Since we're making suggestions about the motion, I would suggest that we follow Officer Lemon's suggestion and impose a penalty as well as our other board member's suggestion. That would be my suggestion.
Well, why don't we vote and see what happens?
Okay, roll call, please.
Okay. Ms. Dabbs?
Yes.
Mr. Demasis?
I'd like some clarification. What, Mr. Trask,
So the motion on the floor is compliance date of April 25th or a $100 a day fine for every day thereafter. If you're not in agreement with that motion, you would vote
I would have
no.
to say no.
Okay. No, it is. Mr. Kramer?
No.
Ms. Vaquesi?
Yes.
Mr. Zableski?
Yes.
Mr. Vesey?
No.
And the motion
Pat.
failed. Need another motion?
I'd like to make a motion. I move based on the testimony, evidence, facts presented in law that the respondent was in violation of sections 25.02 and the definitions as indicated in Article 14, the definitions 241, 213 of the Tarpon Springs Code of Ordinance from the inspection date of 12/13/2014, and that this is be established and that the property must come into compliance by April 26th of 2015, or a fine of $200 per day will be imposed.
I'll second that one, too.
Any discussion?
Let me get this straight. But there is no fine right now, right?
No fine right now.
Okay, second.
And a roll call, please.
Okay. Ms. Dabbs?
Yes.
Mr. Demasis?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Mr. Zableski?
Yes.
Mr. Vesey?
No.
So the motion passes.
Motion passes. Thank you for coming.
5-1.
Thank you.
Thank you, board members.
That's good.
Thank you.
All right, I agree.
Well, I was
Mr.
leaning that
Crow.
way, to tell you the truth.
Case number 14-800000823,
Oh,
1292 Salt Lake Drive. Is anyone in the audience representing this case today? Hi. Have you been sworn in, sir? Thank you. And were you sworn in, sir? Was. Thank you. And would you state your name and address in the microphone, please?
My name is Ayoe, and that's the first name. Call me John. And the last name is Bochu, or Boshu. And Our home is at 1292 Salt Lake Drive in North Lake subdivision.
Thank you.
The Greek Orthodox community here in Tarpon Springs and in Tampa Bay area know me as Father John. So I've served this community here for 5 years.
Thank you. Just your name and address at this time.
Yes, okay.
Okay. And for the city today?
I am. My name is Greg Dobbins. I'm Operations and Maintenance Manager and Arborist for the City of Tarpon Springs.
Thank you. Go ahead, sir.
Well, we received a complaint, anonymous letter about topping of trees at their residence. Did an inspection and found that to be true. We sent a notice of violation 1114. I discussed the case with the homeowner, and he and his wife were very upset over the fact that they had no awareness of there being a no topping tree ordinance. They asked my advice, and I said, well, at this point I needed to interpret the ordinance as it was written, but I suggested that he represent himself here at this board meeting in hopes of seeking a little bit of relief from what I thought might be an extreme fine for this particular situation. We did send a notice of hearing. The property was posted 2/15, and I re-inspected yesterday. They are not in compliance. I didn't expect them to be.
Thank you. Mr. Bochu?
Yes?
Any questions of the city arborist, Mr. Bochu?
No, I just want to thank him for being so candid and so approaching the situation with
Hang on a second.
very.
No
Yes?
questions? Are
No.
there, okay. Board questions?
Any board questions of the city?
Yes, I have a question. What you're saying here, reading this here, because he topped some trees, trimmed them out, cut the tops off? Is that what he did?
Yes.
And you're, due to the ordinances and all that, you're saying that it's $1,860 he needs to pay to the tree fund?
Yes.
Okay.
Do we have pictures?
I provided some materials. I don't know.
No pictures.
I'm going to go ahead and ask a question while he's done. What does it take to come into compliance? He needs a permit, correct?
He needs a permit.
Has he applied for a permit?
Has not.
Okay.
And,
So if he gets a permit, he pays whatever it needs to be paid for the permit, he'd be in compliance, correct?
Well, if this is an after-the-fact situation, the trees
It's
were
a yes
topped.
or no answer. That's what he would need to do. He'd need to apply for the permit, pay for the permit fee, and he'd be in compliance, right?
That, and you would need to either replace per caliper inch with like species or contribute to the tree fund for the amount specified.
That's what I need to know. Okay, thank you.
And here
Did
are,
it kill the trees? I'm not
It
sure.
appears, do we have some photos coming our way?
Hold on a second.
This is,
Could you show that to him and see if he has any objections?
I know, but I don't.
I'm doing all this
I guess I
backwards,
wanna
but.
see how soldered up it was.
Yes, but I wanted to give them the. Okay, thank you.
'Cause I'll have a tree
yes.
trimmed, and, you know, it'll be pretty. Where do you draw the line?
Got that. Any objections to that photograph, sir?
No?
Thank you.
it's your time to make your presentation, sir.
Okay, thank you. And I'm very sorry for jumping the gun, and going ahead. As I said, I'm part of this community since 2003. That was the time when I was assigned to serve as a pastor at St. Nicholas Greek Orthodox Church. And as you may assume, I have a degree of discomfort being here present, but I was thinking that compared to the Last Judgment, this might be small potatoes.
Don't turn this over.
Since 2003, we enjoyed our house in North Lakes. We purchased it from Pioneers, and at the time of closing, we are told that we need to have 4 trees on our property. And there was not much choice at that time, because I believe this is something that came also as a recommendation or ordinance from the city to the developer. And at this time, if you would just open the little booklet that I put together, you may see our street, Salt Lake Drive.
Okay, hang on just a second, sir.
Yes.
Did you review this? Does the city have any objection to this?
No objection.
Okay. Sorry, I just want to make sure. It's being tendered out of order, and I wanted to make sure that there was no objection before it got passed.
Okay, thank you. May I continue?
Sorry.
May I continue? And I just marked from the satellite view a couple of the properties that are around my house that have either 1 tree or not at all, no trees at all. And I'm not sure how these things are working in the big scheme of the code enforcement. Why some houses have no trees, some houses, you know, they have to have all the number of trees that had been planted from the very beginning. So on page 4, it's 33 Salt Lake Drive, you know, no trees, no plants, just a little bit of hedges around the house. 1285, just across the street, again, only 1 tree on the property. And then on page 6, you can see my house. I love trees. I grew up with them. I moved from Transylvania in 2000 here in the United States. And on our property, we used to do this quite frequently, trim the trees, especially when there were some issues with them. You know, the canopy was expanding too much. I'd like to give you the reasons why I have done this. And from the very beginning, I want you to accept that I acknowledge I'm a violator. I've done something that is wrong according to the code enforcement, and I didn't have knowledge of how strict the code enforcement is regarding our trees here in Florida. First of all, these trees were planted quite close to the house. I don't know if there are any regulations about that, but they're about 12 feet. In 12 years, this 12 feet distance became very small compared to the growth of the canopy, of the branches. Given the fact that these trees grew that much in 12 years, we had the canopy overshadowing the roof. Any small wind was scratching the roof and damage it. And then we had a rat problem. The squirrels were nesting in our attic. Another problem was the acorns that were falling down from these trees. They started competing with the St. Augustine grass. You can see in the picture here on page 7, you know, very small oak trees that are growing through the grass. Now, because of the shade that we had over the house, in the back and in the front, there was heavy mildew and black mold that was ever present, no matter how frequently we were pressure cleaning the house. And another point is that my daughter and my wife have allergies from the pollen. Every time when there is a pollinization season for these oak trees, we have health problems, health issues. Now, if you open the booklet at page 8, that was my first violation, actually. I topped that tree in October of 2013. And I'm grateful for that anonymous person that sent this year, the notification to the city that they didn't do it last year or in 2013. As you could see, that tree already developed a young canopy, young branches. And on page 9, that's the tree that I topped in 2014, in November of 2014. On the last page, there is the perspective of the both trees compared, the 2013 and the 2014. We love Tarpon Springs, we love this community, and for that reason, we were planning eventually to keep this property as a retirement investment and come back to Tarpon Springs at that time. For the last 6 years, I served 4 years in St. Petersburg, and I was commuting just because I wanted to have our house here in Tarpon Springs. In 2012, I was assigned to serve in Sarasota, and I still come to Tarpon Springs as a part-time resident every time I have a chance, and make the effort to rent something in Sarasota in order to keep this house here. But it becomes increasingly difficult with the unsavory letters that we always receive from the homeowner association and the iron fist of the code enforcement that, looking into paying this kind of fines for 2 trees that actually are not dead, in fact. If we apply the same reasoning to the human life, that means we have to bury our veterans because they came back from Iraq or from Afghanistan with missing a limb, This tree is not dead. You look at the tree, it has branches, it springs back into life as long as the roots are healthy. I'm not an arborist, and probably I should stop here with all this kind of remarks.
I think we have a very good understanding of your position.
Yes, thank you.
Representative for the city, do you have any questions of Mr. Bochu?
I do not. I would, my last chance to comment, if I can make a suggestion, I would, him being unaware of the ordinance and volunteering to comply from the very get-go, if there's a way that the board sees fit to go back to the original permit fee and original per caliper inch payment to the tree bank in lieu of the expanded 4 times the fine, that would satisfy the city.
Can I interrupt and just ask you, what would that approximate fine be then?
$465.
It doesn't matter. You can't do that. That's not within your authority.
That's a fee, not a fine.
All right. I'm sorry. You don't get to make a decision on what the permit fees are. That's his department.
I understand that,
Yeah.
but he's
making a suggestion that you can't do.
We can certainly set a motion that there be a
Lower dollar fine for the daily.
That's correct.
Yeah.
And then have that in, all I'm trying to do is determine what would be the fee if we went back to the original date, as this person just suggested on the part of the city, which he said it would be fair. So if that would be what he would feel is fair, and we made a fine to match that fee, as opposed to making it 4 times that, I would think that's something that we could do in a motion, could we not?
No, because you need to establish a daily fine. And so you have no idea when he's going to come in and apply for that. So you may think that he can do it within a day or 2 days or 5 days. He may take 6 months, and it may go over that set dollar amount.
All right.
You need to go a daily dollar amount, and maybe it would be a lower daily dollar amount, but that's, you don't, you know, your motions require you to provide that he comes into compliance, and the only way you can do that is the daily fine. Otherwise, if you set a dollar amount, let's say at $400, he may just decide, I don't like the tree. I'm not going to buy the permit. I'm going to pay the $400. Now I don't have to pay for the tree being replaced or pay the permit or whatever. So the daily fine is what you would want to do, like you do like any other violation.
Mr. Trask, could we find him not in violation?
Have you heard testimony that he's not in violation? You have to apply the testimony, and he gets to summarize yet. You know, we haven't got to that point yet, but I just wanted to make sure that everybody understands before we get on this path of, you know, lowering the permit fee. This board doesn't have the authority to do that. The city does. So if he comes into your department and you decide that you want to lower the permit fee, you can do that through your own department, but this board can't. So.
Anything else as a closing statement?
Nothing else, thank you.
Thank you.
I have a question of Mr. Boshu.
He needs to summarize. He gets
We'd like to let Mr. Boshu summarize, please.
I can't ask him.
When would she ask her question?
Oh, you have questions? I'm sorry, I thought you wanted to address something. You know, now would be the time before
Okay.
you let
Mr.
him
Boshu,
finalize.
are you aware that you need a permit to cut down a tree,
Now I am.
but you weren't at the time?
No. And I found out that the code enforcement was voted in 2007, and I'm sorry, I have not checked that.
Okay, just for your information, I don't know of any community that doesn't require a permit. So in the future, well, regardless of what happens here.
Okay, so this would be your time to kind of pull it all together and make a final statement for us, sir.
I accept the fact that I'm not in compliance with the code enforcement. I don't hide the fact that I'd like to get rid of those trees, taking the proper steps and having the permits pulled from the city the way that it has to be done. Thank you.
And thank you.
That will be all.
Okay, at this time, we're going to close the public
I'd
portion of
like
the...
to ask one more question of the city, please.
Go ahead.
All right. Can you, again, sir, and I know it's been asked and answered, but unfortunately, I didn't make a note on it. What would be required for this gentleman to come into compliance?
He would have to get an after-the-fact tree removal permit,
Okay, an after-the-fact removal permit, yes?
and then also pay or donate into the city tree fund on a per caliper inch basis.
I'm sorry.
He would have to donate into the tree fund on a per caliper inch basis and remove the damaged trees.
Okay, and who would determine what that tree fund replacement cost would be?
That's predetermined in the ordinances.
Okay, so it would be just as it's written here, because you had indicated at some point that the city would be satisfied if the determination was made at a different rate than this?
Yes.
Okay, can you explain that to me again?
We can be flexible in doing this and grant to reissue a new permit for an after-the-fact thing.
Okay, so what would, as the city arborist, what would your estimate be as to what this recalibrated determination might be?
As it's stated, 465.
465, okay, as opposed to 1,860?
Yes.
Okay. Now I think I understand the facts of the case. Thank you.
I guess I have a question at this time. I fail to see the violation. Perhaps you can explain to me how that tree that has been groomed aggressively, but has been groomed and certainly will regrow, it still remains a tree and will be a tree. I don't understand why this violation is here at all.
The International Society of Arborists determines that if trees are severely topped, they come back with multiple leaders rather than a single dominant leader, leaving you with a weak tree junction in the branching that's dangerous down the line to property.
So would that just be a matter of personal opinion?
No, it's a safety issue, depending on a single dominant leader tree as opposed to a shrub.
And one more question. Would it be reasonable that the statements that the violator made about proximity and health, that tree in fact was a danger to his home and his family, and then therefore there would be no permit required or no fine about removing that tree in its entirety?
Well, there are other trees of similar size on the neighboring properties that are not posing a dangerous situation to the neighboring properties, planted in the same proximity, and the fact that they're live oak makes them a very strong wooded tree and not prone to breaking. Abrasion on roof can be trimmed. Trees can be lifted to allow air for fungal problems. So no, I didn't see that in this situation, that they posed a danger to property or person.
Thank you.
Can we read the code provision? Would that be helpful?
Please, Mr. Trask, read the code provision.
Okay, just everybody is following along. 133.02D, it's titled in the notes, topping tree. I'm just going to read paragraph D. Except for those tree species listed as exempt or following a declared state of emergency in which trees become damaged in such a way that topping or excessive pruning by or at the direction of the governmental agency becomes necessary, it shall be unlawful for any person to cut down, damage, top, poison, or in any manner destroy or cause to be destroyed any tree regardless of condition with a DBH of 4 inches or more without a permit. And then it goes on to other things. That's the violation.
So thank you, Mr. Trask, and I don't think that tree is damaged.
This tree, for all intents and purposes, is cut down.
Yeah, but that's not the tree in question, is it?
Yes, it is. Okay, did I close the public testimony yet? I think I'm going to take this opportunity to close the public testimony if all the questions are done, and then we're having our board discussion.
Okay, that's a cut down tree.
I'm a pruner by nature, so.
If there's a, well, and, you know, I have acorns falling in my yard, and the trees don't grow because you mow it. And allergies, my ears are bleeding right now because of the pollen. But you don't cut your tree down, that tree is cut down. That's not topped. This tree had trimming, it's fine. And I didn't, I think
what he's showing in that photograph is that the one to the left is exactly what he did to the one to the right 1 year ago, and that shows 1 year's growth.
I don't believe this. You can see the main thing here. That is not this tree a year ago.
I think that's the perfect presentation. Any other discussion?
I think our arborist explained it quite clearly about that severe topping can do to that tree and trees around it. I think he's the expert in trees. And we've been through this before over the years with people cutting trees. I feel really bad for the gentleman. I remember another case where the guy cut a whole bunch of trees, and the fine was huge, or the fee, that's a fee, not a fine.
Mm-hmm.
And it's not up to the code board to decide whether that's real or not real. And we've been through this over the years many times. And the city ordinance is quite clear, and the simple answer, which ought to be published on television and put on every billboard in Tarpon Springs, if in doubt, come down to city engineering and ask somebody.
Exactly.
They're glad to help you. He will go out any time and look at your property and look at your trees and tell you what to do. I'm about to invite him to my new house, look at mine.
Well, and ignorance of the law doesn't make it
I
legal to
think
break.
it's a shame, but it is what it is, and he's being quite generous because he's offering more than he has to offer by law.
I might make a suggestion that we've heard the city's arborist, and it seems like he has a certain amount of sympathy towards the claimant, but nonetheless, at least in my opinion, it's clear that again, ignorance of the law is no excuse. There is a procedure to be followed. It's obvious, and according to the the gentleman here his own testimony, he acknowledges that he's in violation. And I would suggest to my fellow board members that if perhaps we set a compliance date and a low fine, since we've had the testimony of the arborist, how he could come into compliance, go back and get the permit, okay, and allow our faith in the arborist to set a reasonable fine, which would have been $400 and some dollars as opposed to $1,800. Okay, I think we can settle this matter, and I don't think that we'll ever see this particular gentleman in front of us for this particular type of violation ever again.
Agreed.
Could you put that into a motion for me, please?
Yeah, I'd like to make a motion based on the testimony, evidence, facts presented in law that at the time of the alleged violations, sections 133.02D and 133.04 of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until April 25th, 2015 to come into compliance with the code section, or a fine of $25 per day shall be imposed for each day thereafter the respondent remains in violation of the said code section.
Second.
Any discussion? Roll call, please.
Mrs. Dabbs?
Yes.
Mr. DeMossis?
Yes.
Mr. Kramer?
Yes.
Ms. V. Casey?
Yes.
Mr. Sokleski?
Yes.
Mr. Bessie?
Yes.
Motion carries. Excuse me, Board, I'm missing one picture.
Oh, I'm sorry.
Oh, it's there, thank you.
Mr. Dobbins, may I ask that when you have a case, will you get pictures for us from now on?
Yes, certainly.
Thank you.
I have pictures. I'm
And
sorry.
Secretary, will you please enter those into evidence, please? Thank you for coming. Thank you for coming.
Thank you.
Case number 14-8000418, 621 Locust Street. Is anyone in the audience today? And were you all sworn in at the beginning of the meeting? Yes. Please come to our table, and both of you state your name and address into the microphone, please.
My name is Imas D'Alphonse. I live 559 Orangewood Drive, Dunedin. My wife will speak for me today because I'm having a little problem. Okay, so.
My name is Teresa Delphonse, and I also live at 559 Orangewood Drive in Dunedin, 34698.
And for the city today?
Anthony Mastraccio, Building Development Director, City of Tarpon. This is case number 14-8000418, 621 Locust Street. Hope I'm pronouncing it correctly.
That's okay.
Imas,
Imas.
sorry. Delphonse and Teresa Delphonse. This property is in violation of city codes 6-1, building code adopted, section 116.1, unsafe structure / equipment, and then International Property Maintenance Code 9-1, and that is sections 116.1, 304.4, 304.6, 304.7, 304.9, 304.10, 304.15, 603.1, 605.1, excuse me, and F704.2. On March 24th, 2014, we received a complaint from the tenant that was occupying the structure that they had multiple violations on the interior and exterior of the structure. On May 12th, 2014, we performed an inspection of the structure, and we also drafted a letter and sent it out certified return receipt. On June 18, 2014, a notice of violation was issued. It was mailed first class, certified return receipt, and the property owner of record as determined by Pinellas County Tax Collector or the Pinellas County Property Appraiser. Then on January 20th of 2015, a final notice of violation was issued, mailed out first class mail and certified return receipt. The property owner of record as determined by Pinellas County Tax Collector or the Pinellas County Property Appraiser. On February 4th, 2015, a notice of hearing was issued, again mailed out first class and certified return receipt. property owner of record as determined by Pinellas County Tax Collector or the Pinellas County Property Appraiser. And on February 25th, 2015, we posted the property. The property had multiple violations. I'm sorry I don't have the pictures for this violation. There were multiple of small violations. The major one was actually on the east side of the house. It had some of the structural boards missing, so you had a direct rain admittance into the structure. It appeared that they may have still had some roof leaks when I walked through the structure with the tenant at the current time. It had multiple small electrical violations, no smoke detectors. There was a lot of minor issues to the property. I was in contact with the owners, of course. They were very good. And the tenant was actually there. And then as of one point, the tenant, I don't know if she just didn't respond or I wasn't granted any more access to the structure after that point. So then we proceeded with our letters and to get it into compliance. The current owners, I believe they try to make it or bring it into compliance, but as of this day, it's still an open violation.
So no witnesses or exhibits to submit for this case?
No, sir.
Thank you. Do you have any questions that you'd like to ask the city?
No, not at
About
this
what you
time. They've been very good working with us on this. We are.
Just the
Yeah,
questions,
that's-
ma'am.
no
Thank you.
questions.
That being said, now is your time to make your presentation.
The board, any questions from the board? And I have questions if not.
Nope.
When, did these folks own the place when this violation started?
Yes, ma'am.
And it was rented out?
Yes.
Okay. I think I had more, but I can't think of them, so.
I have a question or two. When you made this reinspection, have the smoke detectors been put in service?
After the renter had left, I did not gain access into the structure. So everything up to this point, I believe, is still not in compliance.
Okay, can you give us a better handle, since you don't have the pictures so we could see for ourselves, as to what these numerous electrical violations, although minor, what are they?
Missing fixtures, smoke detectors fall under that, but the actual fixture was missing and the wiring was just left exposed. Open breaker spots in the panel system, where normally when you open up your electrical panel, you have a breaker turn on and off, it was open, so they should install a blank cover for protection.
Let me ask you this, in your opinion as a qualified inspector, would these be of such a nature that potential renter could their safety be affected by this? Possible
Yes.
fire hazard, et cetera?
Yes, it could be a shocking system. So if you did touch that panel box, if you entered your finger into that area or grabbed both wires, simultaneously, you will get shocked.
Okay, in regards to the evidence that there was possible water damage, in your opinion, is this apartment or whatever it is, this residence, is it something that is habitable, or is it of such a situation that maybe there shouldn't be any renter in there or anyone else?
The structure was habitable. It wasn't to the point of neglect or anything that we'd have to force, the vacancy of the structure. So it was minor violations.
Okay, and as of now, you don't really know whether those violations have been taken care of?
That's correct.
It's not currently occupied?
As I know, it was not. I've been down several times, but I've never seen anyone there.
Okay.
Let me ask you this, because I'm not sure I understand. If we know who owns it, can this, and I don't know that they can, but can the city inspector make a request to go in and inspect it?
Yes.
Have you done that, sir?
No, sir. We just requested that they obtain a permit and fix the violations, and we'd go back in and inspect them to ensure
I
compliance.
see, okay.
Okay.
Can you go down through each one of these code sections and tell the board what the violations are? You've so far talked about electrical equipment and you've talked about a leak, but there are at least 9 different violations, and you need to provide testimony to them as to what the violations are in each one of those code provisions so they can make that determination.
Yes, sir. The structural members, they were indicating with the possible leak that anything that is part of the structure, the roof structure, I can see in the back porch, and I think it's a garage area, that the plywood of the roof plywood had a bow in it. So it may have been deteriorated. It may have just been, years ago, they allowed 3/8 plywood for a roofing membrane. That's currently not allowed, but you get a lot of bow in that. But we couldn't tell without actually having a professional go up there and either do some destructive testing or verify it during a rain event to see how bad it was. The ceiling was stained, so if there was an open hole, I'd be able to visually see the underside of the deck. But it looks like it may have deteriorated some of the plywood. So that would be the structural members. The exterior wall was the east side of the wall. Some of the siding was missing. So if you looked at the wall, you'd see the 2x4 stud, and you'd see the back of the actual interior of the drywall. So rain was emitting in there, hitting the interior of the drywall and emitting into the house. The roofs and the drainage, it looked like you had some ponding on the garage area in the roof. Again, I'm not sure if it's just because of the plywood. Today's code is a little different. You have to have a minimum of 1/4-inch pitch to get the water off. Years back when it was built, you could hold and stand water. They believe that the water may have cooled the house, but we're still not unsure. But it looks like the water was settling, and we had a small drip into the house. Again, there was staining on the ceiling in several spots. In the overhang extensions around the exterior house, they had an overhang over the roof where the soffit usually was. Some of that was deteriorated and rotted or actually missing. And then the decks and stairways and porches, the back deck had a lot of deterioration on the boards that actually sit on top of the deck. The actual joists themselves look pretty good, and the front stairs were a little bit unsteady. The building code requires 250 pounds of force on the railing be applied without the railing giving, but when I applied force against it, the railing swayed pretty good, and the steps had a pretty good bow to them. So I believe that the front steps would need to be replaced. And the actual doors, some of the doors were not operable when I was there. Again, the tenant showed me, I inspected them, but I'm not sure if they were operable prior to this. It was a rear sliding glass door, and the front entry door had some deterioration. And the mechanical equipment indicated from the resident that the AC system was not operable. She did try the controls when I was there, and the system did not kick on. Electrical equipment would be the smoke detectors, smoke alarms, the panel. It also indicates Section F under the fire of smoke alarms. Whenever you have a garage that's attached to the structure, Section F of the code requires that you have a combination smoke carbon monoxide detector, and that should be outside of the garage area and within 10 feet of each bedroom. So that's that section. A multitude of these were actually missing when I did my inspection.
Thank you.
Any more questions from the city, for the city? Okay, now is your chance to make some comments or your presentation, ma'am.
Okay. Well, basically, we had some issues with this tenant. We used to live in the house. We moved in 2009 when I got a job down in South County, and it became prohibitive to travel. And we've had a couple of renters there. We had an excellent renter the first year. Second year, it was kind of like it kept deteriorating as far as who we had there. And we had a difficult time getting in there to work while the renters were there. This last person that came in, there was only one person. It was like, great, there shouldn't be too much of a wear on the house, and we explained to her that we would be in. That issue on the east side was something that we wanted to address. So we were aware of it. And she said, no problem. After she moved in, she said she just wanted a few weeks to get settled. That was fine. Then she decided, or she changed jobs, or she wasn't, or we misunderstood or whatever. All of a sudden, she was working out of home, and she worked at night, and she slept during the day, so we shouldn't be there during the day. It became a very difficult situation dealing with her, and we probably should have been more forceful with her. It ended up that we were able to get her out of the house. That was in the middle of July. We got possession again August 4th. and met that week then with a representative from the city and a contractor that we had brought with us to go through things. At that point, then we met with our insurance to go through what things were covered. Some of these items, one of the reasons we needed to get her out, some of the water damage in the house was coming from places where it almost had to be poured on there, and we needed to get in there with enough time to inspect and go through things. This was an experience that I can't describe. I think that I do have pictures of some stuff after she left. We went in on the 16th of July, and were advised not to take possession yet because our final from the courts was not back yet that she would be evicted. She had left as of the 16th. We went in actually on the 18th. And at that point, she had taken one of the counters off, and there was a thing of eggs on the floor left. There was
Tons of food.
food left in the refrigerator, doors closed, power off. It was an amazing thing to go through. Excuse me. But basically, we then, after meeting with the insurance person and getting back what we would need to, what we were getting from that, our contractor had said that since we were taking possession again, there's been no one in the space since we were taking possession again, that we could act as contractor in hiring him. After we met with the insurance person, we then went to the city to see about getting a permit and found out that was incorrect. That since we don't live there, we would have to still get a contractor. At the same time, my husband developed pneumonia, and he basically came through this. He's okay, but anyway, that put us through to about December. End of December, we're done. We had contacted our mortgage company in December and asked about doing a deed in lieu. We are now in the process of doing a deed in lieu. At the same time, we got the other letter from Mr. Mastraccio, and so I came in to see if we could put us right on the docket in February, but that was the end of January, so we were too late to do that. Just to let you know, this is what we're doing. We got your letter for the hearing date set for March, because I did call then and say, put us on the docket for March. We got your letter confirming that, and about 2 weeks later, I think it's February 26th, or February, I'll look right on here. We received this February 23rd. We got the paperwork from our mortgage person to go ahead and they would do the deed in lieu. I already knew about the hearing at that time. I didn't think it fair to them to try and push this through, so I called them and let them know that we had this hearing. They said that'd be fine, but they wanted to pull title again to make sure it was clear. They're in the process of pulling title. I do have my email from, we thought it might get here at some point. It's still not back yet. They had clear title before. They wanted to clear new title. So,
Make sure there was no
yeah,
lien.
to make sure that you had not put a lien on it at this point, they had to do that. And so we're still just waiting for that. And Ting Linamora, who is my rep for that, sent me an email today just to confirm that so that you have that to show that that's where we are. As I said, we're done.
The bank is taking over the property.
Yeah, they will take it. We
cannot
can't put
take
anything more
everything.
into it. This is, so I'm sorry.
Thank you for taking the time to come and share that with us. I believe city questions are there? Yeah. Does the city have any questions of our violators?
No, sir.
Thank you. Do we have any questions?
I have a additional question for the city, if I might. I don't know if is that appropriate? Can you give us an estimate based on your professional background as to how long it would take for this property to come into compliance? If an effort was made to do so?
If an effort were made to proceed on the parcel, again, you'd have to do some destructive testing to see actually, as they had indicated, what is the nature of the leaking. Some was in question when I viewed it, but regardless, I would say they'd probably take about a month, 30 to 40 days.
Does anyone else have any questions? Okay, I'm going to close the public hearing portion of the hearing at this time. And would there be any board discussion?
Do you need any of these? Do you need any of this stuff?
If you felt that it was important to us to make, is it too late for her to submit anything?
You can do it. You just need to show it to Mr. Mastrosio. You won't get
It's
it
just-
back.
It's an email. I have it. It's that, and I think that's it.
I have a couple
here's
of
the
points
other
I'd like
papers
to
that
make
we
if I
received,
could.
and these they have
One
to
is that,
sign
that
anyway, so-
this has been an ongoing situation apparently since March of 2014. That's a long time.
That's
The
okay,
other
because
is
they're
that,
gonna send us a new one.
although the inspectors indicated that the property is habitable, I really am concerned that there's these electrical problems and inoperable doors in the same building. He's indicated that the back door, the slider, was inoperable, and I think that's a potential for disaster. And I also think that it's reasonable that having made the owners aware of this situation back in March of 2014, doesn't seem to me that there's been much effort at all to resolve these issues. I understand, and there was an explanation from the witnesses, but I'm just I'm expressing my own opinion, so I'd like to make those points for the record.
Any other?
Also, yes, also for the board and the record, I go along with you, but also keep in mind that they had problems with their renter as far as gaining access, and also they're in the process now of getting rid of that property, going through the bank and all that. So I'd like the board members to keep in mind, one, that the previous renter made it awful inconvenient, and two, they are in the process of getting rid of it. No, that does not excuse the violations, but I think that should be taken into consideration when we decide what the board's going to do.
Okay, I would like to point out to the vice chairman that according to the city's exhibit, it indicates that the complaint that originally started this issue was from the tenant. So I think that how the tenant might be characterized could be affected by the fact that clearly the issue at least came to the attention of the city through
Right.
the tenant.
Duly noted.
All right.
Yes, sir.
Excuse me?
I'm afraid that the public portion has been
I
closed.
didn't think you closed it, because I had asked you that question, and you asked about me putting that over
Oh,
there.
I'm sorry, ma'am, go ahead.
Yeah, my only other thing is, I mean, I have pictures out in the car of the garage door that she intentionally backed her truck into. We have at home the AC repair thing when we had the AC guy, and he'll attest to the fact that it worked all the time. It was old,
Yeah.
but it worked, and why it didn't work that day did not have
It's
to do
still
with the
working now.
equipment.
Okay.
This is,
Every year I have it. Every year I have the beginning of the summer. I have the air conditioning man come in, clean both air conditioners to make sure they're both on working order. If you go to the house right now, both of the air conditioners are on working order. I haven't touched them since May last year, but the lady was destroying the house.
I also have a letter where she contacted our insurance company to try, and she fell on the property once.
I genuinely
there's-
appreciate, but that was part of your presentation.
Yes.
We listened and we heard that additional part,
Yeah.
but I'm afraid we've closed that
I know,
portion.
and
But I
didn't
will
know
give
had
you an
to tell
opportunity in just a moment to add some more. Does anyone have any questions? Okay, a closing statement by the city, please?
The board, I inspected the house. I've been an inspector for 18 years. Some of the violations there indicate that you need a lot more investigation to see exactly where some of these issues had arisen from. Were they self-inflicted? Very possibly. They did try to work with me. We were in contact quite a bit, and the renter actually did make the initial complaint, but was difficult on obtaining any other information after that and accessing the home after that.
Thank you. And now, Mr. and Mrs. Delphonse, you can make a closing statement and add anything you'd like to at this time.
I'd just like again to thank Mr. Mestra. I do this wrong all the time, Mr. Mastracci. I apologize. Yes. The gentleman from Code Enforcement, he did work with us. He was always very open and honest and would help us figure out what to do, and I do appreciate that. We appreciate that. As I said, as soon as we get the new paperwork, it would be signed off and done at this point, and the bank could take it and go on. But we did have to wait because I did not feel right handing it to them without letting them know that we had this hearing to go to first. So I would say within the next 2 weeks, we should be done. And a new investor is set to take over.
You indicated, I couldn't hear you, 2 weeks, did you say?
I would think that we should be able to, yeah.
Okay.
They have to redo that paperwork and just get that clear title, but that was put through, my understanding is, about February 26th was when she had requested it again, and she said 7 to 10 days. She wasn't sure if that meant business or whatever, but they're checking every day, and I bother her every day, at least once.
Thank you very much. Okay, at this time, I'm going to close the public portion, and we can have some discussion ourselves or entertain a motion.
No discussion.
Well, maybe we ought to just give them a couple of months, and by the time anything is due, they're out of it. I don't know.
I think I'd just make a comment that I appreciate your comments about the fact that repairs have been hanging out there undone for a long period of time, and then at the same time, tenants can literally shut down a property, and an eviction process can take very long, and they can deny access to a property and really drag it out. So there's a real balance between those two things.
There was quite a long time when the tenant was gone in August until today, but nobody's living there. I don't know.
I think we have an opportunity, since this has been ongoing as long as it has, it appears, at least according to the testimony of the witnesses, that given 30 days, the situation will resolve itself and they'll be out from under it. So I just would suggest that we possibly consider, whoever might want to formulate a motion, that they consider that the fact that it appears from the testimony that 30 days would be sufficient for them to get out from under this, and then whatever might be imposed beyond that 30 days, it wouldn't be an issue for them because the situation will have resolved itself, hopefully.
Mr. Trask, I have a question. The property isn't going to magically bring itself into a good state, and what would that formulation be to make sure that the next owner promptly remedies all the things that are deficient?
Good point.
What would be the proper motion? Or
For the city to start holding the case all over again, because that's what it's going to take. What you've got here is that you've got someone who owns a property and wants to pass the problem on to the next person because they don't want to handle it. You have a testimony that they had the opportunity in the last 7 months to fix something that Mr. Mastrosio said can be fixed in 1 month. You got 7 months and they haven't done anything. So now they're going to pass it to the next person. So what's going to happen is the city is going to have to go out there, site the property again, get the property, whoever owns it, go through the process, and it'd be another 3 or 4 or 5 months before you get back here. And we'll be back here the same thing with the same issue, and you're going to be telling the bank or the bank's representative, how come you haven't done the last 5 months? So the goal of this code enforcement board is to bring properties into compliance, not to pass the problem on to the next property owner. And so to answer, I hope I answered your question, but
is there an action, not necessarily. Is there an action that we can put forth today that doesn't allow that to occur? Doesn't the fine or the action stick with the property so that that person inherits it instantly?
That's correct. What's going to happen is that you need to handle it like any other case. This is no different than any other case. Was there a violation? If so, give them a compliance date, and if it doesn't come into compliance, then a fine will be started. And the property owner did the right thing by notifying the bank, because they have a legal obligation under Florida law to notify the bank if the new property owner is going to come in, that there is an active code enforcement case going. But you can't, if you find no violation here, there's nothing that's going to be done, and then the bank is going to have to be, or whoever the investor is going to have to start all over again.
I'd just like to clarify for the record, I don't know, Mr. Trask, if that was based on any comment I made. I don't intend, and I hope I didn't imply that there was not a violation. In my personal opinion, I believe there is. I just wanted to know if in a normal case, whether or not the property's being sold or changing hands, we give a certain amount of time to correct the problems. It's normally 30 days, okay? I asked the city's representative what would be sufficient. He indicated 30 days, so I guess I don't see, as you do, I don't see that there's any difference between this case and any of hundreds that we've handled, at least I've been a party to in the last couple of years. I'm going to make a motion, and let's see if it's accepted by the other board members.
Please do.
And that would be, I move based on the testimony, evidence, facts presented in law, that at the time of the alleged violations, Section 6.1 Building Code adopted, Section 116.1 Unsafe Structure/Equipment, IPMC 9-1 Property Maintenance Code, IPMC 304.4 Structural Members, IPMC 304.6 Exterior Walls, IPMC 304.7 Roofs and Drainage, IPMC 304.9 Overhang Extensions, IPMC 304.10 Stairways, Decks, and Properties, IPMC 304.15 Doors, IPMC 603.1 Mechanical Equipment, IPMC 605.1 Electrical Equipment, IPMC Section F 704.2 Smoke Alarms, of the Code of Ordinances of the City of Tarpon Springs were enforced. The respondent has until April 15th, 2015 to come into compliance with the code sections, or a fine of $75 per day shall be imposed for each day thereafter the respondent remains in violation of the said code sections.
Second.
Any board discussion? Roll call, please.
Mrs. Dabbs?
No.
Mr. DeMoss?
Yes.
Mr. Kramer?
Yes.
Ms. Vaquesi?
Yes.
Mr. Sobleski?
Yes.
Mr. Vesey?
Yes.
Motion carries.
April 15th.
Well, that's
Good luck. Thank you for coming. Thank you for coming, Anthony. Case 13-2031 is complied.
Because I need to get that to my lender as soon as possible.
I have to clear it, it has to be
Yeah,
signed.
we'll get
go out within
affidavits
10 days.
no affidavits of non-compliance
Done.
and affidavits of compliance.
If I can find them. I don't know what I did with them. Oh, they're here somewhere. Let me have, you took my blue pen. Oh, there it is. Oop, I had them already. Yeah, see, you're ahead of me, thank you. I move we accept the affidavits of compliance in case 12-200000034, case 13-800010009, case number 14-8000435, case 14-800000693, case 15-2000001, case 15-800000063. That's the end.
Second.
All in favor?
Aye. Aye.
All opposed? The ayes have it. Thank you.
Okay. Justin, this is a really long meeting, huh?
Gracious. Old business, we have a request for reduction in fine, case number 12-2000034, 1306 East Tarpon Avenue. Is there anyone in the audience today for this property? And were you all sworn in at the beginning of the meeting?
We were.
Super. And would you state your name and address for the record in the microphone?
Monica Coble, Remax Realtek, 4175 Woodlands Parkway, Palm Harbor, Florida, 34685.
Joe Coble, Remax Realtek, 4175 Woodlands Parkway, Palm Harbor, 34685.
We haven't had one of these in a while.
I know that house.
That's my recollection. We really don't want to retry it. We just kind of read our information. We can ask them. The city can provide us. Bobby, how much is the fine? Can you tell us?
$32,150.
What is it?
32,150?
13 or 32?
$32,150.
I seem to be short the written petition. Do y'all have a copy?
It's here? Here you go.
Oh, I'll take it. You keep it.
Well,
And the city has made a recommendation, if y'all,
1360.
and that is totally okay with me.
Want a motion, Mr. Chairman?
I do. I was just going to let our guests know that thank you for coming, but our discussion will be amongst ourselves and our decisions based completely on the written testimony. And yes, sir, we'd like to hear a motion.
I will make a motion. I move that the fine of $32,150 in the case of citation number, oh, I lost that.
12.
The case of citation number 12-200000034 be reduced to $1,360, $1,360. This reduction will occur upon payment of the stated reduced amount if paid within 60 working days of this order. Failure to pay the reduced fine will result in the original amount of $32,150.
My second,
What's the date? What's the date he said?
60 days.
60, okay. Thank you.
Any board discussion? Ms. Dabbs? May we have a roll call, please?
Ms. Dabbs?
Yes.
Mr. DeMasis?
Yes.
Mr. Kramer?
Yes.
Ms. Casey?
Yes.
Mr. Sebeski?
Yes.
Mr. Bessie?
Yes.
Motion carries.
Thank you for coming.
Thank you. Thank you to Gary Sherman and Code Enforcement for their help with the process.
That was easy.
What'd you say?
Good question.
sure.
How long do we
I don't know.
get the update?
I can't hear.
Oh,
I don't believe we have any minutes to approve yet today.
You have 60 days.
You have 60 days.
And do we just need to request an assessment search and estoppel to get the updated payoff?
Yes.
Okay. Thank you.
Thank you.
Thank you.
All. Thank you.
Good luck.
Are there any public comments today? You've been waiting so patiently. Thank you so much. You picked quite a meeting.
yeah,
Usually,
this is the longest. we've
Yes.
had.
last month went 17 minutes.
Yeah.
10 minutes.
Yeah.
Hold on a second
So
with that.
sorry.
Wait a minute, I can't accept that just yet.
Do public comments in the voice?
No?
For us, would you state your name and address, please?
Okay, I did my pledge and everything. My name is Terry Fondrick. I live at 1301 Lily Court, Tarpon Springs. I thank you for this opportunity to testify.
Hold on a
This-
second. You're not testifying.
Okay,
And are you going to talk about a specific property that you want to come before the Code Enforcement Board?
no, yes.
Okay, stop. If you have a code enforcement violation case that you want, you need to bring it through the city. This is a quasi-judicial board. They cannot receive information or
But-
evidence.
Hey, 1 second, sir. I have not been able to go through the city. The city has stopped me from talking to them.
Okay, this
I
board,
have photos showing codes. Please let me give this to the chairman as part of my speech then. Just a speech then. I'll say a speech. I can give photos as a speech, correct?
do you understand what this board is for?
I understand what this board is for. Yes, they're to, I agree with the tenets of the code. They are honorable. They support the health, safety, and welfare and basics of the code.
Right. This code enforcement board cannot hear matters and bring its own cases forward. It has to be brought forward by the city. It would be just like a judge. Well, obviously, you're here to complain about a property that's not in compliance.
No,
What are you here to discuss then?
somehow, some way, it never got to the board. I was told it was going to come to the board. It never came to the board. Then I gave you, as part of that thing, I show you the case history saying that what they have done is said that this thing is in complete compliance of everything.
All right. So you need to take it up with the building official or the city manager.
The building official will not let me into his office.
Call the city manager.
I called the city manager. He would not call me back.
All right, this board can't help you. You've got to understand. They can't, even if they believe that there is a violation, you've just prejudiced them because of the fact that you have presented evidence before the board, before the alleged violator has had the opportunity to question or cross-examine. So I can't have you, as the board's attorney, presenting evidence on a case that will or will not come before it. Okay? So there's nothing that this board can do. You need to, if you don't think that you're getting the appropriate response by the code enforcement board, by the building official, by the city manager, there's one more step.
What?
Appear at the city commission meeting, on the citizens open forum at the very beginning of the meeting, and you will get the attention of the mayor and the commissioners, and they will direct city staff to take the appropriate action through the city manager.
Thank
Okay?
you.
Then you may get to that point. If they decide not to do anything with it, this board is not going to do anything with it either. So,
Well, if they see the pictures,
Third Tuesday,
David Archie.
third Tuesday of every month.
great.
I believe it's at
If
6:15.
they saw the missing things, if they saw the screws coming out,
You
if
you
they
have
saw
to,
this
I
stuff,
think they register in advance too, don't?
No,
public comments?
you can just show up.
and I can give to them the photos of this.
You can do anything you want. You'll have 3 minutes.
Okay,
So,
thank you.
all right. Thank you
I've
for your
sat a long
understanding.
time for this.
Okay.
Good luck.
Thank you.
Time for board and staff comments. I have one. I'm going to get in line first. And y'all may know that Mark Sansota, our past chairman and member, has for personal reasons, has resigned from the board.
Oh, really? Dang.
Maybe I was the only one that knew, so. You know what? He's got a lot of life going on.
Well, that's
And-
good.
And he just saw his calendar coming out and said, you know what? I can't do both things. And so he's taken care of a lot of life and said goodbye to us.
Oh, it's
So we get to
too
see
bad.
Annie's smiling
Get to
face.
say
on
goodbye,
the
yeah.
presentation.
That bumps you up some.
And then we had of course, two folks had to call in and say they couldn't be here today, Mr. Plunkett and Miss,
Becky.
yes, Becky Archer.
I have a quick comment for you.
Yes, sir.
Last week was our shortest meeting. This month is our longest, ever.
Marathons. Feast or famine?
Not since I've been here.
I had them run till
Well,
11 o'clock once.
8
so-
years since I've been here, so.
I have to admit, when I was getting dressed today, my daughter caught me, and that's why. I was thinking, if they don't hire an enforcement officer, we're not going to have any meetings. Maybe we're disassembling, but it appears that the young
Yes.
officers definitely are.
And you're
are-
seriously
Even
pushing
though
on my cocktail hour now.
Go ahead and
so-
say it,
And
Jerry.
even though you were cutting the wire awful close, I am awful glad to see you here, especially after this kind of a meeting.
A thank you to Mr. Trask for taking care of those special moments that we needed, because those are some critical moments
right.
that we needed.
We
to
would
do.
be lost without it.
You're welcome.
And next week's St. Pat's. That's the best holiday of the year, you guys.
We're going all out. A lot of great board interaction and comment today.
It was good.
And that's not disagreement, that was just good discussion. I found that very pleasant. And it's sure nice to see Ms. Dabbs over there instead of
I
down at the end.
know.
Okay, I'm sorry to keep talking. Looks like 4:31, this meeting is adjourned.
That was a 2.5 hour meeting.
You ought to be ashamed.